Good afternoon, everyone. Welcome to today's webinar, Using AI Predictive Analytics to Prevent Legal Abuse, sponsored by Agatha, powered by Optimalex. I'm your moderator, Rosalie Donlon. I've been a practicing attorney, and I am now an independent journalist writing about the intersection of law and insurance. First, some housekeeping notes. Please save all your questions for the end. You can put your questions in the chat, and we'll answer as many as possible. Now, let me introduce our distinguished panel. First, Frank Giaoui, founder and CEO of Optimalex, John Hall, senior trial attorney at Hall Booth Smith, Stephen Rosenfeld, practicing ophthalmologist, and Nigel Shepherd, chief claims officer. In the next 60 minutes, you'll hear how predictive analytics is changing the way complex liability casualty claims are handled. And we'll be using examples for medical professional liability from the moment a complaint is filed to the courtroom and beyond. We're here to discuss what the issues are and how to use predictive analytics to support your strategy and address them. We're also talking about AI in two different uses. One of them is as workflow automation, pure productivity, which Nigel will address, but we're also talking about using AI as predictive analytics to help you support the decisions that you're going to make. We also want to start by talking about using predictive analytics to reduce claim cycle time. First, Stephen, as a practicing physician in the group, closely connected to the insurance world, please start us off by explaining how claims arise from your perspective.
I'm happy to discuss about basically how a claim is born. And we all know that a patient can file a medical malpractice claim when a healthcare professional deviates from the accepted standard of care. And the more common causes might be failure to diagnose, surgical errors, medication errors, negligent maternity care, or failure to obtain informed consent. But today there's a more nuanced drive that is driving malpractice claims, and it has to do with patient behavior shifting due to social media, heightened, heightened or unrealistic expectations, lower tolerance for any perceived errors, or even less than perfect results. And patient interactions can turn into a complaint. Um, if there's less than perfect surgical result, an unrealistic expectation, a failure to read or respond to any abnormal lab work or radiologic imaging, lack of communication, lack of empathy, and even documentation errors or omissions. And to give a quick scenario of how it's a more nuanced drive to malpractice claims these days, I'd give you something from my own background as an ophthalmologist, that a patient is scheduled to have cataract surgery, and we're planning on using a premium lens, what's called a multifocal lens implant, that would give a patient near and far vision following surgery with the hopes they won't need to wear glasses. And as not uncommonly can occur if there's a surgical complication and the surgeon cannot put in this multifocal lens implant but puts in a standard lens implant, and it's handled properly, it's handled according to the proper standard of care, yet the patient now after surgery has to wear glasses, and it can be very, very upset, very disgruntled. And this is a known complication of surgery, as I said, that was handled properly. But it's important that your I's are dotted, your T's are crossed. And I think it's important that the pre-op informed consent should quote that there's a 98% success rate, let them know that 2% of the time there could be complications, that informed consent should include common complications. And after you've had a complication, as we were taught years ago as a resident, the patient you want to see the least is the one you may need to see the most. So here you have a disgruntled patient, a patient who has a hard time grasping why it is they couldn't get the lens they wanted, why it is they're now will remain dependent on their glasses. And the more you just see the patient in the office or touch base with them through phone calls, the better you'll be. And that poor communication after any surgery can also precipitate problems. The patient needs to know what happened at surgery, about their diagnosis, prognosis, and options for treatment. And we've also learned from analysis of previous claims and with the use of AI that it is okay to apologize. We were always taught that apologizing was tantamount to admitting guilt and that it might come back to haunt you in the legal arena. But studies have shown, and even patients being interviewed after malpractice suits, that had the doctor apologized and demonstrated that empathy, it might have gone a long way to preventing there being a claim. And lastly, offer patient the ability to get a second opinion and writing off any unpaid balances are other ways to try to take the edge off a patient who's been disappointed following a surgical mishap.
Thank you, Stephen. Nigel, as the chief claims officer, um, what happens when the patient isn't happy with Stephen's explanation and the complaint becomes a claim?
Before I get to that, Rosalie, let me put some context to the discussion. I'm actually not sure this is true or not, if it's a truthful thing or a myth, but I heard years ago that when Albert Einstein would be in his lab creating all these formulas and doing all his great work, somewhere on the board, amongst the complex equations, he had 1 + 1 = 2. And the reason he did that, because he felt that it doesn't matter how complex the equations got, if 1 + 1 wasn't equal to 2, then everything else was false. And so in discussion today, I want to do the same thing with the premise. And the premise is really, and we should be thinking in terms of every time someone speaks, this is the premise, like the 1 + 1 = 2, that should be somewhere at the bottom of the screen. And the premise is this: the longer a claim stays open, the more expensive in terms of loss and expenses it becomes. It does not age like wine. The other thing I want to do before we getting into the first of the losses is to really discuss the elephant in the room. Predictive analytics does not replace people handling the claims. And I'm going to repeat that. Predictive analytics does not replace people handling the claims. Rather, it removes some of the manual processes that prevents them from managing those claims. And so for insurance companies to reduce cycle time, it's really about fixing the source of the problem. And the first notice of loss, the FNOL, and triage management really sets the pace for their entire claim. Now, initially, when we talked about first notice of loss, it really answered the question, is this a covered claim? It was really designed to receive information, not to really act. Some of us have progressed from that traditional stage to what I would call the intermediate stage. And at that stage, we really automated the FNOL process, but we really stopped an intake. So what really happened is we speeded up the intake process, but then we took those results and really placed them into a manual process, the manual queue, if you will. So at that point, it became the same way as a traditional method. But some of us have then progressed to fully utilizing predictive analytics, which really triggers the full downstream chain of a claim. Coverage is verified the moment the file is created. Severity classifications are set and assigned at the beginning of the claim as well. So the practical result is this: by the time an adjuster gets to claim, about 30 to 40% of that intake work is already done. So what that does is really changes the way the adjuster does his or her work. They can now focus in on some of the more complex parts of the claim. So therefore, the real question at FNOL is this: it isn't how quickly claims are opened. It's about how much information the adjuster gets before he or she initially touches the file.
Thank you, Nigel. Um, Now, we all know that setting reserves is an important component of handling claims. How are you using predictive analytics to set those reserves?
is that initially we would take a look at the reserves in terms of, because of limited information at the FNOL stage, we'll use a statistical reserve. Some companies do that. For example, they may use $2,500 for a homeowner's claim, or they may use $50,000 if it's a BI claim that's non-represented, and maybe $75,000 for a BI claim that's represented by an attorney, right? Or an educated guess. What predictive analytics has done is, even at the FNOL stage, it reviews similar cases to the one that you're looking at. And based on analyzing data from similar cases, it could assign a more what you call feasible reserve, if you will. So the outcome is you have improved consistency and accuracy of your reserves. This is an actuary dream.
So once you've answered the reserving question, how do you then use predictive analytics to fully assess the claim?
Generally speaking, when we manage a claim, we do a dance. And what I mean by that dance is, and some of us have natural rhythm, some of us have two left feet, and some of us have taken dance classes to kind of better ourselves. But why I call it a dance is typically a loss comes in, we go through some motions, some steps, and then somewhere down the road, usually, particularly if it's represented by an attorney, a few months before trial, you start thinking about making a settlement. Oftentimes, that is prompted by a demand that comes in from plaintiff's counsel. Therefore, you get anchored to that number, and then negotiations proceed. Predictive analytics tries to remove the longevity of that dance. They quickly gather relevant information to provide confidence in your ability to pull that trigger. I once had a boss years ago that said that some of us, we would hold a gun and we would say, aim, 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 aim. And what you need to do in claims is you need to actually fire the gun, pull that trigger, pull the settlement trigger, if you will. And predictive models would also help you in terms of negotiation aid. One of the hardest things, particularly if you are not a seasoned claim professional, is you're on a phone negotiating with a plaintiff's counsel who's been doing this forever. And so you may not have that degree of confidence, but by using predictive analytics and having them as a negotiating partner with you gives you that confidence to not only, number one, make the initial offer or demand, and then come up with a settlement value that you feel confident with. The other thing is that if the file actually goes into litigation, predictive analytics will help you make litigation management decisions as well. It will help you in terms of, is this a case you want to take all the way to trial? Or perhaps this is a case that we may think about doing an early settlement in the earlier stages of litigation.
Nigel. Stephen, in your experience, does data predictive analytics actually change behavior, or does it just flag what experienced adjusters already know?
Well, in my experience, it has really helped enhance how we handle the claims. And normally, when a claims comes in, before the days of AI, and we had to assign a claim to an outside expert or even one of the experts on the claims committee in the company that I worked for, it can take weeks to months to get this information. And then you're getting the benefit of one doctor's assessment of the viability of the case and whether it's a case worth defending or going to trial or settling. But now with the much quicker data analytics, you can have all the data processed in a very digestible form and indexed for you, as well as giving you an idea of what the success rate would be going forward to trial, what the settlement limits might be if you decide to settle compared to hundreds, if not thousands, of other previous similar cases. Um, so that has helped us a great deal. And lastly, having been with a malpractice insurance company, for us to settle in that particular setting, it required uh, to get the insured to agree to either settle or go to trial. We had to have their permission. And sometimes it's difficult to convince them to do what we think is right. And it's one more bit of objective data that we can share with the insured that the AI analysis, the predictive analytics state that we have a very low chance of winning a trial and they ought to consider more seriously settling. And by the same token, if someone wants to settle, and our data analytics say that we have a great chance at prevailing at trial, then it's useful to help try to convince an insured that we should go to trial, that this is the case worth defending.
Great. Thank you. Frank, what is the benefit when claims are handled earlier in the process rather than later? Can we quantify it? And how does predictive data analytics help realize this benefit?
Thank you, Rosalie. As a lawyer, I would say it depends on the case. But as a data scientist, when you have a lot of data and you have a good hypothesis and the experience of what happens on the field, multiple cases build patterns. And so, what predictive analytics and all AI technologies bring in general is to identify the different patterns and to assimilate or assign this new case, arguably this new claim that just opened, into one particular pattern. So, because we can help identify patterns for each injury severity, each demographics of claimants and their law firms, of course, the number and nature of defendants and each jurisdiction, the defense team is now equipped to assign the case to this pattern early on its journey and proactively offer a substantial or at least a fair settlement amount. If this settlement amount is not accepted early on by the plaintiff side, at least it serves as an anchor. And now you are in a position where they have to justify why they did not accept the offer. Of course, we are speaking of a bad case here where you'd rather settle. I want to give an example, and those two examples I have in mind are both in medical professional liability, where we could identify in one particular carrier the fact that nothing would happen essentially during the second year. And in this situation that I have in mind, after the ninth month, that was a good time to start and settle. And in another situation, we knew that after 2 years, a little bit after 2 years, it was already too late. So what's happening during this year where most of the claim adjusters are really letting the case document from the plaintiff side often is actually that you are accumulating potential loss. And we have quantified, I mean, everybody knows that in the claim adjustment space, we have quantified the potential loss for each individual day, and that was about $1,000. So if you leave 1 year with not much action, that is already $350,000 you have lost potentially on a serious case. And that is an immediate return on the investment you have done on your predictive analytics tool. So although ROI may take some time, because those systems are learning over time, if you act upon earlier information that you have demonstrated to be more accurate, you save immediately on, of course, the productivity of your team. You save on the legal fees because you involve the lawyers at the right moment. And you save also on the outcome, on the indemnity itself. And there are very, very well-documented benchmarks on that.
As they say in the gambling world, cut your losses.
Yeah.
So, John, we've seen what happens when you catch a complex claim early. What happens when you don't, or plaintiff's lawyers are not realistic in their ask when the claim goes to litigation? And that's where things get legally dangerous, right?
Yeah, your comment was cut your losses. I prefer to stack your deck. We should be prepared on these cases. Many of these cases settle, as we know, but we got to stop and look at what the litigation environment is right now. you have a group of plaintiffs lawyers who are more concerned about generational wealth, and many of them have money or through third-party financing. They really aren't caring about their client or the outcome. And with this generational wealth mindset, they are already in AI. I talked to one of the creators of Plaintiff AI who has seen the light and left that world and gone to the defense side. And he's indicated that though the plaintiff's bar has shown time over time, they're getting 20-25% higher settlements and higher returns and quicker returns because of AI, because they're overwhelming the defense bar. So they have a mentality, let's get in, let's get our information, let's set a high amount, anchoring, as Frank says, except the other way. They're anchoring at ridiculous sums. You know, last 5 cases I've tried, the plaintiff's lawyers asked for greater than $100 million in the jury, and the demands were in the $200 million in a single plaintiff case, in a med mal case. And so dealing with those issues, we got to understand that landscape and how it's trained. And to do that, we have to be proactive from the start. And I'll talk a little bit more about it, but in the first 120 days, you should not wait for your defense counsel to say, well, we have to get this deposition or we have to get that expert. With the combination of the speed and quickness that you can utilize through an appropriate AI integration into your practice, we can know experts, we can know the theories of the case, we can do those things that if you take experienced attorneys and experienced claims professionals, they should be able to come up with the value of the case within the first 120 days, that 2 years from now, if you're at trial, it's not changed. And by the way, you haven't changed either. And what you did to create is a reputational point of view from you and the people that's doing it, that you're going to set a value early in the case if it has one. You're either going to decide you're going to try it and you're going to tell them that and take it to that. But truthfully, very few cases go that view because of cost and others. But you're going to set a value on the case with them. They're going to know from their intranet that you mean what you say. When we're giving our first offer, that's within the range of where we're going to settle the case. And we've seen repeatedly from that, when we do that in cases, that plaintiffs lawyers, once they learn that, they settle early if it's a case that we want to settle, or those that don't understand that yet and haven't looked at the intranet, they tumble to the number right before trial. The defense number, if it is still kept and held, which is a reasonable number versus a plaintiff's generational wealth number, in the current environment can be and should be put out and done. And you have to decide if you're going to settle early, you've got to anchor early. And I think what we've got to also understand that you're being watched. Plaintiffs lawyers now are more aggressively suing carriers, suing defense lawyers if they get a verdict. And they're doing it based on not dotting the I's and crossing the T's. And the only way that can be even enhanced is with AI. We can look and have connections, and we can be able to second guess. I call AI, it's an arrogant genius in the room that needs to be checked, needs to be second guessed. And when we do that, if we have its ability to go fast and our ability to analyze, we're going to be better at evaluating these cases early and getting an earlier resolution to the cases based on our terms versus reacting to the plaintiffs. I prefer to be prepared. I hate going into a mediation or a deposition and the plaintiff anchored it, they're at 100 million. The case is worth 4 or 5. We're at 3 or so to get them to know that they know we're not going to go much further. And that somebody in the room, a claims person or attorney, what do they know that we don't know? And the answer is, if we've done our job, nothing, and we should stick to our guns and rely on that data as long as we've done it appropriately.
Right. Is litigation funding, I know we didn't talk about this before, but is litigation funding something that you factor in when you're looking at the predictive analytics?
Well, I think you've got to do it to understand your opponent, know who the plaintiffs are. First of all, there are 2 type plaintiffs out there in the world right now that are pursuing what would be a catastrophic or large exposure case. They're those plaintiffs that have generational wealth. They have maybe 5 to 10 attorneys in their office. They're handling 12 to 15 files. They're going to take 30 or 40 depositions. They're going to threaten you. They're going to threaten the carrier. They're going to threaten the attorney. They're going to threaten the insured with bad faith. They're going to threaten the insured with losing their wealth. And they are focusing everything on those cases when they go in. For those attorneys that don't have generational wealth, we saw a decrease in frequency after the 2008 financial crisis because they couldn't afford to carry a credit line. But then what occurred in the early, about 10 years ago in terms of being out here and 5 years ago being prolific, even those attorneys without generational wealth now go get a venture capital person or a venture capital company who's underwriting. By the way, it's probably the same venture capital that's underwriting the hospital bonds in a hospital case or a company bonds. Venture capital is on both sides of this issue, and through third-party funding, these attorneys who can't afford it through generational wealth, they're able to maintain the lawsuit because, and it is, I would hesitate if you don't have generational plaintiff lawyers, you probably have 60 to 70% of non-generational plaintiffs lawyers in a catastrophic case are being funded by a third-party funding. I'm sorry, I didn't hear the question.
Now, I'm just asking Frank what his thoughts are.
Yeah. So about your question on litigation funders, I can tell you for a fact that they are using those techniques. So if on the defense side we are really not at par in the battle, and so they identify earlier on those cases where they know there is a highest potential outcome because many factual reasons, and also because the plaintiff is more defendant, is more sympathetic. So they are using the technology, they are sharing the data, and on the defense side, we don't do that much.
What are your other thoughts about using predictive analytics in litigation from the defense side, Frank?
Well, one thing I would add on the legal side in general is you can use also predictive analytics, and I hope John will confirm that, to select who are the lawyers or who are the law firms that are best fit for this particular case. And we all know that there are lawyers who are much more performing on trial, and then some others who are much more performing on, let's say, on negotiation. And it's not fair to compare them in the same ballpark. Some situations you need to go to trial for many reasons, for principal reasons, because it's a good case and you don't want to get a bad reputation. You are very strong in this particular jurisdiction and you need to go on litigation and trial. But on many, many cases, and we know that is probably 95, 96% of the cases, you need to settle before there is any trial and out of court. And here you can compare how long is the negotiation, how long is the claim settlement with this law firm compared to that other law firm in this jurisdiction compared to the other jurisdiction. And these are just data. It's not only relationship. Of course, you want to work with people you like to work with people you trust, but there are also some facts and some data that you can compare. And taking a lawyer or law firm who knows how to make the difference in early settlement, that is back to what you save. So the savings is also in this situation.
Nigel,
Yeah,
I think you had some thoughts here.
Yeah, the one thing I want to add is this. We kind of talk about social inflation. And for me, I think the real term is claims inflation. And I'll give you an example. A few years back, we took a case to trial. And the jury, in their infinite wisdom, came back with a $260 million verdict. This loss involved a trucking accident. We had admitted liability. There was one fatality. The person died on the spot instantaneously. There was no conscious pain or suffering. We were talking about a 27-year-old male, no dependents, who wasn't married, making $30,000 a year. We couldn't do the math, but somehow they came up with $260 million. The good thing is we're able to settle it post-verdict for $1 million. But the lesson is really this. A few months later, we're taking a second case to trial. And for the first time, my CEO called me and said, look, I know you think this case isn't worth much. We have $1 million policy limit. He said, I would have no issue if you paid the whole $1 million. Thank goodness the decision was left to myself and to my team. But we used data analytics on this particular claim. And I said to him, based on my team getting together, based on the data analytics tool that we had, this is a very, very minor case. And I'm confident that we can do really well on this. We're not going to offer the limits. And so we ended up selling that case for $50,000. And the lesson really is this, is that it's more about how we react to hearing those big verdicts out there. Because quite frankly, most of us in the industry, we probably take 1% of our cases to trial, if that amount. So everything is really about claims settlements and how can you best get that and have the confidence. And this is where I felt that data analytics tools play a big role in giving you that additional confidence to make a reasonable settlement and not be afraid because you just read it on the front page news that there was a $300 million verdict somewhere else.
Yeah, if I could say just, Nigel, I agree with you. What we have, aberration verdicts are still less than 0.00% of all verdicts on those limited cases that we try. The problem is aberration settlements, where people are afraid of those verdicts and psychologically are pushed to run those numbers because of that risk of that one unlikely point of view. And Frank, I'll comment on your view about measuring firms, and I think you should. But I tell you, all insurance carriers in the C-suites have got to understand claims is not an add-on to be looked down as negative and a cost. Claims is your business, and until you give claims the resources and the authority to move earlier, they're not going to be successful. Yeah. And if you start measuring your law firms, one thing you got to measure is, first of all, I think they ought to be getting your values. Our book, Reviving Fairness, talks about doing this within the 120 days. I'll circulate it around later. But that if you start doing this, then the claims department has to be ready to respond to the predictive analytics. They've got to be ready to, you can't say, hey, we've got this case of, our claims committee is not going to meet for 4 months and we'll get to it then. You waste time, you waste money, you angered the plaintiffs, you made them invest more time. So the claims people have to respond. And you can't go push your plain people, hey, don't put up, why are you putting $100 million reserve on this case in the first 3 months? Because it's worth it. Well, let's wait a little bit. We've got to change how we look. And there are companies, I don't know the frequency. I'm not in the carrier world, but I see it. When people tell me, well, we can't get to a value on that. We can't make that, even though you evaluate and you get it to those points. And hopefully predictive analytics, AI, will put the company in a better position. But if you don't change, just because you got a Maserati, you're still going to lose the way to lose the race to a Volkswagen if you don't use what you have and get in the race. And so I think companies have to step up and make a change. This whole industry's got to change. You're not going to have people wanting to do claims. You're not going to have people wanting to defend these cases if the C-suite doesn't start respecting claims and their attorneys, and they don't start moving quicker.
Yeah, I don't know if I may jump in here, Rosalie, you tell me, but John is mentioning change, and I would add communication. So 2 things. Those platforms of predictive analytics and in general AI technologies are also an excellent tool to share within the team. Within the team inside the carrier, so with the actuary, the claim adjuster, the in-house counsel, but also with your defense counsel. And as early you share with your defense counsel on the same basis, the best they will be equipped to defend your case. That's on the communication. And the change, I agree with you, John. Very often, one of the misconceptions is, all that is technology. All that is engineering. I'm not an engineer. By the way, I'm not an engineer myself, right? Economists and lawyers. It's not true. It's actually half true. The other half is change management. You don't start by selecting the technology. You start by selecting the use case. You start by knowing if you want to reduce the cycle time, if you want to reduce the legal fees, if you want to return on investment, if you want to close 100% of your case or just let them go. Or you start also by identifying the champion. Who is the person within your team who is best equipped to do that? Not everybody is equipped to do that, and we know some of us are actually reluctant to change. So coming back to your point, John, we know there are always the rule of 3 tiers. There are always the one tier who will be the champion for change. And there will be also one tier who will be laggard because, in their mind, maybe they are close to retirement and they feel learning AI will not be returned within their business life or business activity. Well, personally, I feel that's short-sighted because they will live 20 years after working and they will still need to use those technologies. But that's okay. You just bet on your champion and then you implement the metrics. Those metrics and processes are with the champion, with the use cases, what makes a project work. Of course, once you have done those change management tools, you have certainly AI, technologies, data, integration, but that's the second half, not the first.
Yeah, very quickly on that point, you're right on communication. The quick example is, you finally get to the point you want to get a case resolved, and you're in a mediation, and you turn to your defense counsel and say, "What should we do next?" And they don't know where you're going. How in the heck can they advise you on what move to make if they don't know where you're going? And that's part of the communication. You can have the best predictive analytics in the world. You can have the best tool in the world, and if you don't use it, and then you don't apply it through communicating and getting everybody involved in it, you're not going to go anywhere.
Great. Thank you, guys. Now let's talk a little bit about the practicalities of how to implement AI predictive analytics in the organization. Nigel, as the person who's actually done this as the claims officer, what are the key decisions that need to be made up front?
Rosa, I think before you really get into anything, you should really develop strategic plan. Like, what are you really trying to accomplish? What are the issues you're trying to solve? But really, in terms of step one, you should be discussing in terms of who and whom do you require to have buy-in, all right? Because it doesn't matter what you bring to the table if there isn't buy-in in this new product or this new plan, you're kind of setting yourself up to fail. And then how are you going to communicate the change to the team? Because as I said before, the only people that like change are babies in dirty diapers, right? Nobody else likes change. So, we talked about some of the challenges before. Initially, if you bring a plan to the table, what we generally hear is that, we've always done it this way while you're trying to make a change. Are you trying to implement something that's going to cause me to lose my job? This is never going to work. Or, okay, great. But now you just gave me more work to do. So you have all those challenges and hurdles. So it's really important from strategic position to really discuss how you plan on communicating that change to the rest of the team. Also, what training is needed? You're given a brand new tool, but you don't have the proper training in how to use it, then you might as well not have the tool. In my household, we have a rule. If you have to plug it in or it goes to the battery, my girlfriend does it. If it's just a hammer or a screwdriver, then it's my responsibility. I don't have the training to use an advanced tool. She does. And so I take that knowledge to the workplace and I say, look, it's like giving me a power tool without any training. It's a dangerous proposition. So training is very important, but I feel it's often overlooked. Oftentimes what I see is we've not gone out, we've made this contract, we picked a vendor, we've got this brand new tool, let's plug it in and hope it works. Okay, no, it's not going to work that way. You have to have training involved in that. And the last thing I would say is you have to have the ability to monitor how well the tool is working. Right? And not only monitor, but also define what success looks like. Right? And so if you're going to use data analytics and predictive analytics in your claims operation, at the end of the day, what results are you trying to get? Is it purely just cycle time? Is it cost savings on expense? Is it cost savings on indemnity? What is your measure of success?
Thanks. Stephen, what are your thoughts on the implementation?
Well, I agree with a lot of the points that Nigel had to make. And I think that it is important to try to find a champion or someone who's comfortable with change, comfortable with trying to learn something new that will be additive to what we're doing in claims. And as stated before, that the data analytics will make for much faster and more efficient processing of the data that comes in. And that's something that really isn't in the hands of the employee. That's really using the technology itself, which is so no one has to be trained adding data. And we, for example, Optimalex will process the data much more quickly than a human can and index it for you. But it is also important to let the employees know that we're not bringing in this new technology in hopes of cutting jobs or having somebody lose their job, but we want it to be complementing what we're doing, that we're still going to have to, in addition to getting the predictive analytics, looking at a case, it doesn't replace the old-fashioned still having an individual review the case and collate the data and ultimately make a decision. Um, and they still have to the employee needs to be diligent in their chart review, because the only way you can even refine the AI is by challenging it down the road and having it make more changes that may be more germane or more helpful to our given company. Um, and it's something that I think uh, there's many companies now on Wall Street even that are demanding that their employees start utilizing AI. They're monitoring how often they're using AI, and not in hopes of necessarily changing the number of employees, but realizing that people have to start feeling comfortable with change, learning how to harness that change. But it is slow. But they have to be taught that it's really being done to make things better in the business in the long run, to make everybody more efficient, but to try to maintain business and the employee count as usual.
Frank, from the vendor side, what challenges or what makes the process go more smoothly?
I would say two things: collaboration and change management. Again, I want to give you an example, two examples actually. One example, if this where this client, the champion was clearly the chief claim officer, and they knew from the beginning that among their team there would be some people who would be reluctant, skepticism, additional work, as we said. So smartly, they decided to implement those technologies the first year as just optional. You use it, of course, we had the training and explanation, onboarding, etc. But the chief claim officer said to their team, you use it if you want, on any case you want, if you want. And of course, they knew that at the end of the year, only a portion of them would use, and one third more or less did not use. Guess what happened? Those who used the technology had fun using it. They learned a lot and they got best results. So, by definition, on the second year, everybody was using it and it became mandatory. So, it was a natural mandate to use those technologies before getting any settlement authority. You would not get more than 500,000 settlement authority if you don't use it. So, here is a very smart, smooth implementation where the chief claim officer is themselves the champion, but not necessarily them. The chief claim officer can identify the champion within the team, and this is also possible. Of course, they would provide the support, or the chief claim officer would require the support of the CEO. The second thing I would say is collaboration. Of course, you need to use the low-hanging fruits, right? Don't start with something too ambitious. For the beginning, it's not the easiest to win skepticism, but collaboration is important. AI is not magic. One of the misconception is, there are actually two misconceptions. One is what we have said about, AI will destroy our job. The other misconception is, s- everything is on the shelf, plug and play, and it will work the next day. That doesn't happen like that. Artificial intelligence, predictive analytics technologies are learning, and they will learn as much as you put your own knowledge in it. At the beginning, you will have benchmarks that are probably accurate to the overall market because we have a lot of data, but they will not be very relevant specifically to your on track record. So there is back and forth to improve the accuracy on any algorithm. And the fact that those clients are spending the time initially makes them the winners for the second and the third year.
So Frank, could you talk a little bit about this slide?
Yeah, so we mentioned about choosing your use cases, appointing the internal champions, and sharing the KPI. I think Nigel shared that. Key performance indicators are what you will measure in the implementation. Is it a success? Do we adjust? Are we into our closing rate? Are we exceeding our claims length before closing? Those are really before any implementation, before any technology. And this is only the responsibility of the business leader. And I can share more on the slide if you don't mind, Pedro, to put it back. On the second part of the slide, you have all the engineering and technology part. And here, of course, you do that together with your vendor. What is the governance of data? What data can we map? We have data on this huge database of the vendor, and we have our own internal data. How can we map that so that we can benefit from the federative learning? We can benefit from the learning of other part of the market. The fifth point is training models collaboratively. I think I just mentioned that. And then only deploy the tool. You don't need to make systems integration the first year. You just need to make secured file transfer protocol. So of course we build the exclusive environment so that your data is completely protected from the internet. And once you are confident and comfortable with using it, then we can integrate with your own core systems. We don't integrate initially also because your IT is often fully booked in their roadmap, and we don't want to have this bottleneck.
Great. Thank you. Well, that's all the time we have for today. It's been a fascinating discussion. Thank you, panel, for your insights. I want to let the attendees know that the full implementation checklist from Optimalex will be sent to you by email after the webinar. And now we have some time for questions from the audience. As I said before, please enter them in the chat. And to start us off, Nigel, as the Chief Claims Officer who's done the implementation again, from the carrier side, what's the biggest misconception carriers have about adopting predictive analytics in claims? And how did you address it?
Yeah, I think Frank touched on part of this. The fear that they're going to lose their jobs because of technology. And if you look back, I think we go through this every 3 decades or so. You know, back when the internet came out, people thought they'd be losing their jobs. When we started having computers, people thought they're losing their jobs. Now we have AI and predictive analytics and data analytics. Once again, the fear is I'm going to lose my job. So that tends to be one of the biggest misconceptions. The other one I would say is that there is this thought or this feeling that the current way works. If I get on my soapbox, feel free to pull me off. I don't believe it does. I mean, if you look at the plaintiff's bar, they're spending a lot of money. They're doing litigation funding. They're spending a lot of money in technology. They know which adjusters settle cases quickly, which don't. They know more about us than we know about them. And unfortunately, I feel that sometimes when I say we, and I'm talking about the defense side, the insurance carrier side, oftentimes we lack what Frank was talking about before. This has to be a collaborative effort, right? And oftentimes we have this misconception that we're going to fight this battle. And when I say battle, I'm talking about there is a battle between the insurance carrier, defense firms, I guess, the plaintiff's firm. There is a battle there. We often feel we could win that battle by fighting it by ourselves. And we can't. We have to collaborate with predictive analytics vendors, defense counsel, insurance carriers, and so forth, whatever resources that we can get, because our measure of success today tends to be, I don't mind losing to plaintiff's bar as long as I don't lose as much as my competitor. And as long as we have that mindset. So I come out of a fight, I have one black guy, but my competitor has two black guys, so I won. Okay. No, we both lost. We're both going home with black eyes. We have to move away from thinking this is a battle that's going to be fought solely by ourselves. And I think the first step is to really get partners that you trust and that really understand what the future looks like. And that begins with getting the right vendor, getting data analytics as part of your toolbox, and working closely with defense counsel, and then not being afraid of sharing information with other carriers as well.
Great, thank you. John, from a legal perspective, does having the AI-driven predictive analytics create more obligations for the carrier? Is a net positive, net negative? Where do you see it coming into play?
I think in the current state of the world right now, it has the potential, but that just involves people using the tool. And if you don't have the tool, eventually that's going to be for a carrier on a bad faith side. If you don't have the predictive checking, that's going to be the negligent part when they go sue you for bad faith. Now, obviously, when you have it, you have to communicate about it, follow through, and show that you made considerations, understanding that ultimately it's your knowledge. And I will do one shameless plug, Rosalie, if I can. I write novels under the name Everett Hall, my middle name, and my latest is AI Lies and Murder, about a omnipresent AI in a hospital that helps patients in treatments and accused of murder. So I hope we don't get there actually, but surely in this case, you'll find that I won't give away the plot, but in the end, because they had good predictive analytics and they followed through and kept their AI up to date, they won. So, that's what we need to do in real life.
John, would you talk a little bit about, from a legal perspective, the risk management of having predictive analytics?
Well, the biggest risk management is the bad faith scare, that if you get a verdict against you, your insured signs over their rights to sue their carrier and sue their attorneys. And if you have this data, you have these opportunities. An aberration verdict's a bad verdict. We have a checklist that we go through in each case. And if I had that checklist on a piece of paper and I didn't check those things and report those and deal with theirs, and there's a bad verdict, then I'm going to be in trouble. That same, take it off the piece of paper and put it on the computer with predictive analytics. They are checklists, and they're things you should be looking at and you should be considering. You can say tomato, tomato. I believe by having it, you're more protected from being subject to bad faith than if you don't have it and you fall through the cracks that you didn't even see.
Nigel, we have a question from the audience for you. How long has your AI tool been up and running? Can you share some of the results or outcomes since using the tool?
Yeah, it's been up and running for about 3 to 4 years now. What I would say is I see the results on both ends of what I call the severity barbell. And what I mean by that is, think about lifting weights in its two ends. One are your smaller, less complex claims, and one is your really big complex claims. On the smaller side, we use data analytics because we found that if you get cases, and I'll define these casualty liability cases as 50,000 or below, if you settle those cases within the first 45 to 60 days, right, it's 3 times less expensive than if you start getting 60 days plus. Okay. And so we use data analytics because oftentimes you assign your more junior claim staff to those smaller exposures that may not have the confidence in terms of making a first offer or understand what the values of the cases are. So we implemented data analytics to help them make faster decisions and more accurate decisions on the small end. On the large side, with the more complex liability claims, it also helps you, as I said before, we kind of had this dance we were doing. It helped you to speed up the process, make better and informed decisions, better and earlier reserving, which is quite important on the particular larger cases that we had. And so we saw great results from both ends of those spectrums. We, in the end of the day, we saw anywhere in terms of losses, the loss ratio up to 3 points on that, 25% on expenses, and so forth. And the cycle time could be up to, depending on the level of the case, could be anywhere between 25 and 50% time saved.
Thank you. Stephen, in the last couple minutes we have, is there anything you would like to leave the audience with?
Well, I think that to echo what's been said, that the speed of dealing with claims does make a difference. With the claims committee and the malpractice company that I worked with, we had found, as Frank had pointed out, that 9 months seemed to be the sweet spot. That if you had a case you were considering settling that case within the first 9 months, there was a dramatically reduced amount of settlement money that was paid, and also in terms of the overhead, it was significant savings in terms of legal fees, expert witness fees, etc. And that letting claims persist beyond that 9 months, there was a significant greater loss and greater economic impact. And we're also now seeing, just as has been alluded to before within the medical arena, if you now are treating a patient and you get AI to help you treat the patient, should you put all your faith in the answer or the diagnosis or the workup you're getting from AI, or should it be tempered with your own clinical experience? And as John alluded to, if you get sued because of a bad outcome and you didn't use AI, you can be liable for that. On the other hand, if you say, well, I did everything the AI told me, but you got a bad result, they'll say, well, you should have tempered that. You should have, used your own clinical experience. And it's a conundrum, and it's going to have to shake out and decide really what is best. But it seems, as everything, that, it's the truth lies somewhere in between, and that you have to temper it using common sense, your own judgment, and with the benefit of AI and the predictive analytics.
I want to thank all our panelists for attending, for their wisdom today. And I want to thank our audience members for listening. For more information about Agatha, Optimalex, or any of the topics we discussed today, you can contact Frank at Optimalex Solutions, or contact@optimalexsolutions.com. Or you can change it to just Frank if you really want to talk to him. He's got
I will be happy to do so. Thank you, Rosalie, for moderating this panel, and thank you everybody for attending. Let's keep in touch. Bye-bye.
Bye-bye.